Basically what I did is I went up on the internet and looked at what people were saying, which ones were the best ones, and I ordered the best one was.
Oh, okay. Is it a long one like this big with lights that go across?
Yeah.
Yeah, that's a good one.
Yeah.
Let me know when you're ready.
Filling in for.
It's broadcasting.
Good
Good evening, everyone. Welcome to tonight, Wednesday, December 21st, meeting of the Holmdel Township Zoning Board of Adjustment.
Okay. In accordance with the Open Public Meetings Act, NJSA 10-4-10, and the regulations governing remote meetings, NJAC 539 1.5, I hereby announce that adequate notice and electronic notice of this meeting was provided in a notice dated January 19th, 2022, that was sent to the Asbury Park Press, 2 River Times, posted on the bulletin board, and on the main access door to Town Hall, filed in the clerk's office and posted on the township's website, www.holmdeltownship.com.
Roll call, please.
Ms. Catherine? Dr. Blumenthal?
Here.
Mr. Burkle?
Here.
Ms. Campus?
Here.
Dr. Latif?
Yeah.
Mr. Luciani?
Here.
Mr. Orfanatopoulos?
Did very well, and I'm here.
Ms. Perez? Here. Dr. Shaw?
Please rise for the Pledge of Allegiance and then stay standing for a moment of silence to honor the police and military wounded or killed in action. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Just a couple of modifications to the agenda. First, want to add an item to the agenda. Loretta, who has been our secretary, got moved internally in the township offices to a new position as office manager upstairs. And we have a new secretary for the zoning board. Courtney, here. I want to officially welcome Courtney to Holmdel, and I'd like to make a motion to appoint Courtney as the secretary to the zoning board. Is there a second?
I second it.
All in favor?
Yeah.
Aye. Opposed? Thank you and welcome, Courtney.
Thank you very much.
Make that official. I guess Valerie is not here tonight, so seat Jill for all items on tonight's agenda. By way of clarification, what was item 1, an application for 7 Clark Way, will not be heard. The applicant has withdrawn that application. Item 2, we will hear in just a moment. Item 3, continuing hearing on Verde Woods. Some of their witnesses could not be here tonight, so they asked to postpone and continue that hearing to a date next year. So we're going to continue and carry that application to January 11th of 2023. That evening is the reorganization meeting of this body. We will not hear the application that night, but until that night, we don't have a calendar for next year. So at that time, we will have discussed dates with the applicant and carry it to another date in the new year. Without further notice. Okay, then after that we have 2 resolutions, minutes and resolutions. Item 6, the resolution for the Dementia Center. Ask the board to table it for tonight. It's a lengthy resolution. It's some 35 pages. We got draft 2 yesterday morning, draft 4 at 4 o'clock this afternoon. It's being refined. It's a complex resolution for a complex application. We want to make sure we get it right. I've been through half of it twice now because of the changing drafts, and I prefer that we have a little more time to review it, for everyone to review it carefully and get any comments to the attorney. So we'll table it for tonight. Now, for that, only those 5 people who voted in favor of the resolution at the last hearing meeting can vote on the resolution, because it is a resolution to approve, and hence only the 5 who voted in favor of the approval can vote on it. We can either carry it to our reorg meeting on January 11th, or we can create a special meeting just for that item, say, next week. Since it's a holiday week, people probably don't prefer that, and I'm seeing head shaking no. Okay. So we will...
But just to add, though, if you wanted that, you only need a quorum of 4. You only need one vote, one yes person to be here to vote on the resolution. So technically, you could do it with 4 people. If you're around next week, you don't need any of the professionals if you want to do that. If not,
I
January
think
11th.
the sense is we'll defer that to January 11th.
I only say that because I spoke with the applicant's co-counsel. They were okay with carrying it. They'll consent to that. So we're under a timeline. They've already consented. We're a few days past already. But obviously, the sooner the better. They recommend it, but they will carry it to consent to the...
Now, that one we'll probably do on the agenda on the 11th of January.
It's only 2 weeks.
Yeah, so anyone give you a few more minutes, hours, to read over that very carefully. If you do find anything that...
Bob didn't want to read anymore. He's like, no, I don't want to.
A lot of miscellaneous items have been clarified as the resolution has advanced. And I think thanks to Marty for all the work that went into it.
Thank you, Marty.
So if anybody has any other comments, or if members of the public want to take a look at that, consult with the secretary during business hours, she'll have copies of it available that people can look at.
When it's in final form. Right now, it's still in draft format. So as
okay.
I just mentioned to someone, technically, it's work product until we get it in final format to vote. Actually, until it's really voted on, it's not an official document. Having said that, we did tell some of the neighbors, they could see the conditions, so no problem. My opinion of the board, I'm sure, is the same opinion to getting you that final version, the whole thing, if that's what somebody wants to see, but it probably will not be until, after the new year, I'm guessing, given the length of it. And but a lot of the board professionals and others have commented, so it's up to these 7 people now to give it one good look over. But it'll be before the 11th, but probably not tomorrow. I don't think the special conditions are going to change much, though. And I'm looking at one of the members of the public. So I know you've seen those special draft conditions only, special conditions and specific conditions. More than likely, they'll stay in pretty much that format that you've seen. So.
Yeah, I mean, what his attorney is referring to is, through the course of the hearing, agreements were reached with the applicant that so-and-so would be made a condition of the approval, and those all become special conditions. There are also general conditions. You got to pay your taxes. You got to follow all the rules that apply to almost any application. And then a lot of the rest of the resolution is a reiteration in brief of what went on over the 14 public hearings that were held, the testimony that was given, the arguments that were made, the board members' summaries and conclusions.
Marty, for clarification, all board members can give comments. The ones that are entitled to vote are the ones that said yes, but all members of the boards, whether they voted or were here, can make comments.
Yeah, you can make a comment again, but if
Okay,
your
just
comment's
wanna
not
clarify.
accepted by the voting members, you could.
Well, it might be
not accepted.
clarification to one of the special
I
conditions.
accept clarifications from anyone.
Thank you.
And I'll listen to even members of the public. As I told, we can't guarantee your comment's going to be agreed to, but absolutely want to hear if you have a comment. We want it to be right? We don't want it to be a misunderstanding or something.
I think that's quite generally, from my point of view, on any of the hearings or anything like that.
Yep.
We welcome comments from any member of the board, whether you're seated or not, and from any member of the public. Because we want to get it right. And it's not unusual for someone else to see something differently, to point out a better way of saying something or whatever.
And it'll only make a difference if there's a disagreement, and then it'll be what the board that is able to vote on votes on.
Right.
Otherwise, most likely it'll be accepted.
Yes.
I think we all be in agreement, too, whatever the clarification is.
Yeah.
Well, no, some of the wording,
Well,
we
We're not,
we
it's
needed
not
to.
on the agenda now.
Yeah, I know, we're not talking about it, but anyway.
Good.
Yeah. Okay, with that, let's move on to the actual agenda. As I said, item 1 is withdrawn, so we don't need to hear that. And just for clarification for the board members, they were seeking a variance with regard to building a pool, and that involved some setback variances and the like, and they have apparently reconfigured the pool in the backyard, so they don't need any variances, in which case they don't need any approval from this board. They simply need to apply for the construction permit and go through the normal construction process. With that, now moving on then to item 2.
Okay. Item 2, 12 Jennifer Drive. Ina and Arthur Lasbenick, Block 30.01, Lot 7, in the R40A zone. Zoning Board variance number 464. Applicant seeks variance relief for lot coverage of 30.8%, where 25% is permitted, for installation of an in-ground pool. Relief also needed for pre-existing mother-daughter.
For the applicant.
Yes, good evening, Mr. Chairman and board members. Mark Lexstein of the firm Lexstein & Lexstein on behalf of the applicants. And I have seated next to me, Ms. Lexstein, if you wanted to state your name.
Hi, Ms. Ina Lezepnik, 12 Jennifer Drive.
Is your husband going to testify too, or just,
He's,
is he, just in case?
You might as well, Ms.
We swear in everybody now, so I just,
Yeah,
in
sure,
case you
that's
will,
fine.
just if you stand up and raise your right hand. Do you both swear to tell the whole truth, nothing but the truth, so help you God? I'm sorry, I forgot. Our professionals, same thing, swear to tell the truth, nothing but the truth, so help you God? So for the record, our board professionals have been sworn, and both, Mr. Lexi, both of your clients have been sworn.
Great, and the only other witness we're going to have is our engineer is also here.
Oh, okay, well, why don't we?
Yeah, if you
swear
want to
in
do that
just
now, that's fine.
Just, do you swear to tell the whole truth, nothing but the truth, so help you God? And just state your name for the record,
Gary Chang.
and then when you introduce them, you can go through his.
That's fine.
Okay.
Then, Courtney, are notice and escrow all in order? Do any board members aware of any conflict with any, the applicant or their professionals? Are you aware of any conflict that we
I am
have?
not. Thank
Fine.
you, Mr. Chairman.
Why don't you go ahead and start your presentation? Tell us why you're here and what you would like us to do.
All right, Ms. Campus accurately relayed the variance relief that we need. We don't think we need any variance relief for the mother-daughter, and we'll explain why. And that's obviously the elephant in the room that we need to deal with first, so we're going to deal with that first. So I'm going to ask my client first to discuss the current setup of the house and the way that it works.
And maybe, not to interrupt you, Mr. Lexi, but I think we should put on the record that there's been a conversation, at least with our planner.
Yes.
I think there's some agreement that what you're going to testify to, in fact, is agreed to by the township. Kate, that's accurate as far as?
Yeah, we can, we can let them describe the setup of the house.
Right.
I can describe, where the township stands just based on, township records, township permitting, township ordinance, the way it's a unique situation. But, I think that they're doing their best to rectify it, and, I'll leave it to the board's discretion. But my opinion, just going into this, is that also no variance relief is required at this time. But I'll let them explain everything, and then I'll describe the background.
You can slide the microphone over.
Sure.
So she's talking to it.
All right, Ina, if you could just describe what the house is, the way it's set up.
yeah, so we have, it is a 3-car garage home. There is the main entrance that leads into, which is our residence. It has a kitchen, a living room, dining room, a great room area, 4 bedrooms upstairs with 2 bathrooms. Off the great room, there is another door that leads into where my parents are living. So my parents live with us. They have off the room, from the great room, that door, they have a hallway. And so the 3rd garage is off their hallway. So they have access from the 3rd garage into their portion of the house. So they have a hallway, they have a living room, a kitchen, and 1 bedroom upstairs with a bathroom upstairs. Downstairs, they have a half bath.
Okay. And just to make it very clear, there's absolute access from your portion to where your parents reside.
Yes.
There is no wall. You
No.
do not need to go outside in order to enter into their portion. Is that accurate?
Yes.
Okay, and I'll also represent to the board, I was there tonight, I walked it, and it's a smooth transition. You just walk straight over to their portion of the house. And so essentially what it is you are a single-family home, correct?
Yes,
And you just happen to have 2 kitchens,
yes,
and you just happen to have 2 doors
Yes.
that enter into the premises.
yes.
And is this home exactly the same way, the house set up as it was when you purchased the premises?
Yes,
And you received the CO when you purchased the premises?
yes.
So, Mr. Chairman, we would submit, and I think your planner will agree, that based upon that, this is not the traditional mother-daughter in the sense that it's a that it's a 2-unit dwelling. It's a single-family dwelling that happens to have 2 kitchens. And let me ask, would you submit it, if it would make the board happy, a deed restriction that will even further clarify that this is a single-family home and not a 2-family home?
Yes, yes.
Thank you. And that's all we have on that subject. I mean, it really is not that complicated in our minds. I just hope you agree.
And it's 1 gas meter.
Yeah,
right?
it's-
So we have
right.
1 gas
Oh.
bill.
Oh, that's important.
Yeah.
Yes. And so we'll
Additional
ask that
on.
also. Is it 1 gas meter, 1 water meter, 1 sewer meter?
Yes, yes.
I
One
mean, this is
cable?
a single-family home in and out.
1 cable bill?
1 cable bill.
Their name,
1 cable bill.
So the only reason this came up is because there was 2 kitchens on the first floor.
That's
Yes.
my understanding, yes.
So did Lonnie have any input on this?
Lonnie, I've talked with Lonnie about this several times. So essentially, in 2004, the prior property owners, and this is, I go through a lot of this in my letter, the prior property owners applied for a zoning permit essentially for exactly what they just described. And the prior zoning officer gave them a permit for it. It was different things where, there was the different connections from the garage were described. There was no mention that it was a second dwelling unit, things of that nature. That they were properly permitted at that time. They passed, all their inspections. This applicant, they purchased property around 2008. They got a CO then. So then when this application came in, Lonnie had not been there with the time of the 2004 approval. But she looked at it and said, well, the township does have a kind of unique ordinance, which I believe is, let me just pull it up. I believe it's 30-60, which says characteristics of a multifamily dwelling. And it offers different characteristics that kind of look at what makes something a 2-family or a 1-family. And it really gives the zoning, it's a unique ordinance because it really is for the zoning officer to decide at that point. And they go through a decision-making process, and they go through characteristics of what's indicative of either a single or a multifamily dwelling. And, some of it is kind of, it's not exactly yes or no. It's not, exactly a checklist. It's something like, are the facilities in close proximity to each other? Are they separated? Are they on a different level? Do they have a full kitchen? And then they also have characteristics that are not indicative. And that says, no separate entrance, no separate utilities, no separate, open connection within the dwelling unit, no firewalls, things of that nature. So essentially, this is based on my read of this, talking with Lonnie, and some kind of also some established case law, really, which is that when a zoning officer makes a determination, it's generally assumed that they took this into account, and the determination is really assumed to be valid. So that, I think, is what we have here, is that it's a unique situation, but the prior owner applied for a zoning permit. And this, by the way, this ordinance was in effect in 2004. So ideally, that zoning officer would have looked at this. And she looked at what was being proposed then. She looked at this ordinance and she said, okay, this does not meet the criteria for a multifamily dwelling. This is an addition. This is an addition where they're building kind of a separate suite within a single family house, but it does not make it a multifamily house. So she wrote a zoning permit. Prior owners built it. They had it approved, they had it inspected, they did everything by the book. And so then when this applicant purchased it, it really came to light as part of this, this process of them also trying to do things by the book and get a variance here. So I think the question is really that I think what also, and what Lonnie basically, the way she, and I don't want to, I'm not putting testimony on the record for her, but she took a separate look at it where she was like, if this had come before me, I probably would have said that it was a multifamily, a two-family dwelling. But that's not what the prior zoning officer thought. And, now we're just really here to get on the record that, that we're really kind of upholding that, even though we're way past the period of appeal or anything like that, that's not really a formal determination, that we're really just, putting on the record that this, having the board determined that this applicant is not in violation of any prior permit or anything like that. And also, and they've also are willing to, and I put this in my letter, and I've also discussed it with the board attorney, is that they are willing to agree to a deed restriction to be, recorded with the county clerk's office, that this second suite in the dwelling will not be used by anybody outside of family members, and that would run with the land for, whoever buys the house next as well.
Question, when the approval was given back in 2004, did it include a full kitchen at that time?
It mentioned dining facilities, but I don't know if it mentioned full kitchen. What does it say? Reserved dwelling.
Because if he approved it without a kitchen, and then a kitchen was later added, then that's...
It would have had to be inspected, though, and the thing is that this is also done under a prior owner.
So our paperwork doesn't show anything if there was a kitchen there, or not a kitchen, or a full kitchen. And it's one thing if it just has a sink. It's another thing if there's a stove there, hoods, and that kind of thing. Because, I know the other past zoning officer, and it's hard to believe that that happened.
Your garage, great room, dining suite. It does not say, it says dining room, it says dining area, but they would have seen it all. That's, I think, and that's kind of where this is coming from, because they do have all the records that everything was properly inspected at that time.
And there was a kitchen there at that time.
That's the next one that I have, the other inspection paperwork I have, it was the CCO when this applicant bought the house, and they received a CCO then with the kitchen in there. So that would have been based on the prior paperwork. So unfortunately, I can't answer whether, from what my documentation says, what the township documentation says, is that the kitchen was built at the same time as the rest of the interior suite addition, and that all the township officials at that time knew about it, and they inspected it properly, even though it's not specifically recorded on this zoning permit.
But don't you find that unusual that it wasn't recorded that the kitchen was inspected?
I do, honestly, I do, but...
So do I.
We weren't there.
None of us were there.
Yeah.
In fairness to the applicant, all we know is we came in, we filed all our papers, we received all the approvals from the town saying everything was good to go. I can't speak as to what happened with the previous owner and what they did.
Yeah,
Of course not.
Yeah.
And I can't hold the applicant responsible because they bought the house the way it looks. So
Exactly.
they assumed that everything was legal.
And the town told us it was at the time that we purchased.
And
So.
just two kitchens alone isn't a trigger, because it's not unusual for a house to have a second kitchenette,
Right.
or eating in the basement, a bar, or whatever. And where you draw the line is going to be a fuzzy situation. You have to look at the whole situation.
Yeah, and Mr. Chairman, I agree with that statement. My parents, their house, they have a kitchen downstairs, they have a kitchen in the kitchen. My mom likes to cook, and there's definitely no one else living in that house other than my mom and my dad. So it's not uncommon, as you said.
Right, and there's a lot of situations. People have kosher kitchens, people have summer kitchens,
Right.
people have all different kinds of kitchens, and that's...
Indoor, outdoor.
Right, and that's one of the reasons why I think the township at one point tried to put these categories as to what makes something a multifamily dwelling. But then it also goes to say, it's like, well, if you only have a half bathroom and not to have a full bathroom, there's a lot of, it's I think that I think that, it is complicated. And I agree that it's a little, my first comment, when I saw this was, Dimitri, was, why isn't the kitchen listed on the zoning permit? And, you know how Lonnie is pretty sharp. That was her first question.
Exactly. We're on the
And-
same page.
And then we went over some of the back paperwork. And, she's basically like, we don't have it written on here, but it looks like everything was done by the book. And that whoever inspected that property would have seen that kitchen. Because it was built, as far as we know, it was all built at the same time. But yeah, I agree that's like kind of like a, ooh. But it's also like, if it did it even without the kitchen, sometimes because you can access through the garage, you can access from outside, but you don't have to access through outside. And I think I would also say that this is one of the reasons that the township generally discourages this type of thing, because it can just be very sketchy, even when people are trying to just provide a second living quarters for their immediate family members. It can devolve into a lot of these questions. But this is one that, it was approved, and, from my perspective, if they're willing to put the deed restriction on, and they're, and I think that, there no more changes will be done, they're not going to put up a firewall or anything like that. I think that I would feel comfortable with it from a planning and zoning perspective, but we do leave the final judgment to the board.
Yeah.
I have a-
Ask Marty, in that regard, do you feel that a deed restriction would be an appropriate way of trying to limit things and prevent further confusion going forward?
I think it's the best way. It's off record for everybody to see at that point. If you can't undo, so at this point, if you're not going to blame the current owner for what somebody else may have done or not done properly, deed restriction is absolutely solves the problem, quite honestly.
Yeah, I think, I can't remember if it's come up before this board in particular.
Yes, it has.
Yeah, where, even when say someone gets a condition of approval, that's not something you always see, in the title search.
That's right.
And so that's the case where something like this is recommended to be a deed restriction.
Who's going to word the deed restriction?
It's Mr. Lexington will do it, but all easements and deeds get actually signed off on by township council, not me.
Yeah.
So it'll be between Mr. Lexington and...
Right, because that wording depends on how they put down, when they say family member, what does that mean?
Yeah.
We have
Is that-
examples of that. Sometimes it'll be just like a list. It'll say like immediate family is
Immediate
generally
family.
defined by law, just a generation above, generation below, siblings, things like that. But there are legal definitions for
Okay.
that. I would also say that I usually do see a copy of that of those when they go back and forth. I don't always look at them, but when it's an application that I have a lot of that I have background on, I'll work with the attorneys.
So I mean, undoubtedly, the completion of all of this will fall into the new year.
And yes, because we can't do anything until the resolution is adopted anyway. So.
Correct. So then anyway, you accept responsibility for drafting this, and if that's appropriate, you can share it with Kate and with Marty, and then with the township council, we don't know who that's going to be next year yet.
Fair enough.
I could offer a suggestion to any concerns that you may have, is we've done this for other conditions. We can ask Mr. Lexington to draft the deed restriction before we vote on the resolution, to have it at least before that meeting, and we'll have Kate's confirmation and possibly even Collins's confirmation, or whoever's a town attorney, or at least our opinion, even if it's not signed off on, that it's appropriate. So
Yeah, it doesn't need to be in final.
that's right, and that way it gets us to the point where at least we know the format we're acceptable. We can accept that format, and I think that's appropriate.
We know 100% that Lonnie will be here, so can't we have her
She's not
review?
here for forever either, so.
Well, she'll be here.
No, we can, yeah, Lonnie's very familiar with this, and we'll get her opinion as well.
Okay, thank you.
And you've already spoken.
I've spoken to her about this several times, including yesterday.
Okay,
And I would just say, if you're going to approve this tonight, either this issue or when we vote on it, is I would limit it to immediate family members, and let there is a definition that the courts look at. I wouldn't get into any more detail than that, to be honest with you. I think that's sufficient enough. I'd be happy with that. I don't know if the applicant's counsel would, but I think that's the appropriate terminology.
Yeah,
I'm fine with that.
Yeah.
Again, that's their intention.
That's right.
So no one has anything, so there's no reason to object.
good.
I have some comments or
Go ahead.
something on it.
Francine.
I'm listening to all this, and I'm really trying to figure out, except for that the utilities are all one, what really tells us it's a multifamily as opposed to a single family? Now, I understand what you're doing, but when I'm listening to this is a multifamily dwelling because there are two families living in it. So it's going forward, how, as the township, do we, say we're not going to approve, it's kind of, which I think you mentioned, it's a very gray line. Where do we draw the line that we say this is not converting a single-family home? And we've got some huge homes in this town that I could see people setting up apartments and making them multifamily. So how, it's not so much against this applicant, but the township to protect ourselves. We shouldn't be sitting here and discussing small details to decide whether this is a multifamily or a single family. And the only thing I heard that may convince me that it's not a multifamily is that all the utilities are going under one thing, so it's very hard. But you can rent to somebody and ask them for a portion, and I'm not insinuating that's what you're doing. But here's my thing, that's your intention, and I guess the deed restriction will protect us. But going forward, like what happened with you, we don't know whether there was a kitchen there before when this was approved. You bought it, you were told everything was all right. Somebody buys it from you and decides, this is great, this is a two-family home, and starts renting it out.
Well, that's what the deed restriction is going to prevent.
Yes, that's what I'm saying. But how do we not get into this situation all the time? That we have to ask you to put a deed restriction on your home.
It's impossible. I mean, I heard of one situation within Holmdel recently where there was a single-family house that was occupied by 4 families.
Mm-hmm.
And the owner and each of the families got a violation. And we can't all track everything in this town.
No, right.
It's an enforcement at that point. I mean, there's no part of town that allows multifamily, if I'm not mistaken, right, Kate? So, other than doing it illegally.
But that's what I'm saying. If we don't have an ordinance that's going to keep, we can stand behind, we have a problem with enforcing that.
One of the problems you're going to have, and nothing to do with this applicant, is I know the court's definition of what a family is very hard to deal with from a zoning perspective, because family, as we think of it today, is not necessarily what the courts will look at as a family.
Mm-hmm.
You could have a bunch of unrelated people all living together, and they call themselves a family, and that causes, that can be a problem. So that's not our issue here.
No, and I don't mean to.
As far as an ordinance is concerned, I know that's a problem that all zoning boards are facing, and all towns in their zoning ordinances are facing.
No, and I respect that you're deciding that you put a deed restriction on it, because at least it gives us
California, I guess, in the last year or two, the state put out a zoning change. You can't mandate single family. Every unit can be multifamily.
So that's crazy too. So.
Yeah.
And I mean, if this was our neighbors, and I wouldn't want 2 families living next door. I would want just one immediate family.
But this is one family.
This is one family. That's what we have. One family.
It's no different than them living there and having their parents live with them with one kitchen. They just happen to have a second kitchen. I mean, that's the only difference.
No, and I think it's wonderful that you have your parents with you, so I don't mean to criticize.
And in fact, Dr. Duffy, when I was doing the tour tonight, that's where the kids were. We walked in, they showed me, I'm like, where's this famous second kitchen? And the kids were in there.
Yeah.
So that's where the kids were spending their time.
Do any board members have any other questions on this aspect of this application, on this particular issue?
Well, since they have to put proofs on if we don't agree, I think we should at least do a straw.
I was just about to do. Let's see, not a formal vote, but just let me get a nod of heads. Do all the board members agree? You don't have to, but start. Gaurav, is this approach okay? Gene?
Yes.
Jill? Yes. Dimitri?
Yeah.
I'm okay. You're fine?
Actually, I have no issue with this because I'm thinking of adding a kitchen in my house. I'll tell you why. Because what we cook as back home Indian food is very messy and smelly to my kids. So that's the reason that It's not a bad idea, basically, short answer is yes.
Okay.
Yes, yes, I'm fine with it too.
Yes.
Okay. Okay, can we put this piece of it to bed, and let's move on to the next?
Thank you. All right, so the next issue is the swimming pool, which is the real reason we wanted to be here in the first place, was with the swimming pool. So I'm just going to ask, can you just tell the board why you want a swimming pool?
It's just for recreational purposes. So my daughter's a swimmer. She wants a swimming pool. I'm a teacher. I'm home in the summers. I really want a swimming pool. Him not so much, but I really want one. So that's it, just for recreational purposes.
And how many kids do you have?
2.
2. And you said they enjoy swimming.
Yeah, so they're on a swim team. They're on the Holmdel swim team and a competitive swim team.
Okay. So that's why they want the swim team. That's why they want the swimming pool, so they can create great swimmers for Holmdel. And I don't know if the board has any questions. Otherwise, I was going to put on the engineer.
Go ahead.
Okay. Who wants to start? Hi, Gary. You've already been sworn, just for the record, and I don't know how much of a voir dire you want me to do, but you are a licensed engineer in the state of New Jersey?
Yes, I am.
And have you appeared before land use boards in the past?
Yes.
Can you give the board an idea of approximately how many?
Probably over a couple hundreds, and mostly in Ocean, Middlesex, and Monmouth County.
Have you ever been before this board before?
No, I have not.
Nevertheless, if the board doesn't have any other questions, I would submit him as an expert in the field of engineering.
Any questions?
So I have a question. Engineering as far as what? What kind of engineering?
Land use, civil.
Civil engineering?
Yes.
So how are you involved with this pool? Did you design the pool?
I designed the pool, yes.
Okay. I have no objections.
No objection, we'll accept the witness.
Okay, great. So we went, I think the board does have, and I don't know, do we mark this? Do you want to mark this, the plan in?
If he's going to testify too, we should mark it.
Yes, if we could, please. I think the board, everyone has this. This is the, let me just make sure I have it in the right direction.
Mark it as A1. Just tell us what we're marking.
So this is the swimming pool grading plan dated 7/16/22. Gary, did you design this plan?
Yes, I did.
Okay, and so this is the plan that you submitted. This is the plan that you recommend that the applicant prepare.
That's
Do we
correct.
have any more?
What? You don't have a copy?
Do you have any more, Courtney? Or?
I just have my
Okay.
copy.
Yeah, I don't
I have an extra copy.
We have an
there.
extra.
Yeah.
We don't have any on this side either.
Let's get rid of that.
That's what happens when you have an application earlier on and the packages get lost. I know. I'm a board attorney also, and I know what happens.
I got it. Perfect.
Thank you.
That's fine. Thank you. Okay, can you basically walk the board, if the board's ready, into what you are proposing as far as what you've designed for the floor plan?
Because of the constraints of the backyard, we set the pool back 25 feet from the rear setback line, and pretty much we have a constraint on the left side with the septic, so we set it back 20 feet, which is the minimum setback regulation. And so we're pretty much pigeonholed into that area where we could put the pool. And we're proposing pretty much a walkway on the right side, and also a walkway towards the house side, and a bigger patio area for lounge chairs on the left side.
All right, so there is a natural hardship on this property based upon the septic field being there.
Right.
You are definitely limited in where you can place the pool.
That's correct.
Okay. Now, I know the board engineer, Mr. Bucco, did produce a letter, and I don't know if the board has that letter. It's an email, actually, dated August 31st, 2022.
So, just so we have a record, we should mark that because it's not an official review letter. I would like to, we had this before, right, Bob? So let's mark this as an exhibit.
I have
What date?
B1.
B1, I would guess. We should do it just.
It's August 31st, 2022 at 8:09 a.m.
Yeah, we received it before the last, right here.
Now, I'm not sure if you want me to walk through each one of these points, or whether Mr. Bucko wants to take us through it. I know all boards do it differently.
I think you have to tell us what you're going to do and from all that
But
list,
that's fine, we'll go through the exact list.
or your engineer.
Yeah.
That's fine, yeah, you don't want to hear from me, because I don't know what I'm talking about. All right, number one, are there any engineering issues associated with the pool construction?
There is not.
There are not, okay. And Mr. Bucko, if you have anything you want to jump in, please do not hesitate to do so. Two, the applicant should provide testimony on how the backwash water will be handled.
There will be no backwash because they utilize a cartridge system, so there's no backwash. But in case they do want to empty the pools up, then you could use a flexible hose and just run it to the driveway. So, but there won't be any thing in the backyard.
Sorry, that doesn't work. That doesn't work, but I'll let Bob answer that.
Well, I was going to say, if there's no backwash, and you're going to use a what?
No, I'm just saying, in case they want to empty the pool, you know,
Yeah,
just
no,
run a
what
flexible
backwash-
hose,
yeah,
right?
But what backwash system are you going to be using?
It's a cartridge system, so,
Cartridge.
yeah.
Okay, so my objection comes to when it's the summertime, when there's a lot of rain, and you have to drain some of that water out, where's that going to go? Can't go into the street.
Well, I mean, usually, you know, the pool water, it's usually 4 inches lower than the coping.
Right.
So, I mean, unless you have a 100-year storm, I mean, that it's not going to overtop.
We had 3 inches earlier this week.
Yeah, I know. But mostly all the water, that's the beauty of the pool, is that it has a retention aspect to it. So when it rains really hard, or even if we get 3 inches of rain, that pool will just fill up, and then it'll eventually come back down. But it won't need to go out as a discharge.
Well, Bob, not that I'm disagreeing with you, but we have an application that we're going to approve later that the applicant put in a dry well and a rain garden, 2 things that this board asked them to do. And we talked about it, and everybody remembers that. So I don't think this pool is any different than that pool.
Well, I think the one thing that hasn't been mentioned yet,
Especially because this coverage is
well,
5%.
that's going to be it. The Environmental Commission almost always says no to coverage increases, except if there is some mitigation by some kind of stormwater management for that. There are parts of town where there have been significant flooding issues over the years. The town does have an ongoing current study with Collier's firm of stormwater throughout the town because of these flooding issues. And the key is and there was a partial study of northern Holmdel done by Rutgers, and they identified the problem is too much impervious coverage in the upstream areas, leading to too much water flowing too quickly downstream. Most newer subdivisions are engineered with some sort of detention systems. Even newer subdivision is more so. And usually such engineering of the whole subdivision takes into account the allowed impervious coverage. If you're going over that, who's taking care of it? So if you're the ones asking for an increase in coverage, the simple reaction is for us to ask you folks to do something about compensating for that increase in coverage. And that can be done by any of a variety of mechanisms. And what we typically ask is for you as the engineer to come up with a good plan and have that okayed by our engineer. I mean, depends on the topography of the property also, because you don't want it to risk flooding onto your neighbor, which is leading to litigation between neighbors, and that's never a pleasant thing either. But if we can avoid that kind of thing at the beginning by an appropriate design, whether it's simply dry wells or maybe some rain gardens, depending on how the property is located, where to do that, to offset the increased coverage And our engineer is certainly familiar with the variety of green BMTs that exist these days and how to make that work to minimize the impact on everybody.
Gary, could something be designed for what they're talking about?
Yes, we could design dry wells to mitigate the increase in coverage.
And I checked with my clients, and they're agreeable to that, and we could, and if you want to make a condition upon Mr. Bucko signing off, we're fine with that as well.
You may also want to, if you're going to do a dry well, you may want to tie in your gutter systems from your roof into there. Normally, if the water is generated on your property, it should stay on your property. It shouldn't go anywhere, including the street. Street is not a place to let the water go into. So if the engineer can design a dry well or a rain garden, whatever way he wants to do, and if you don't know what a rain garden is, your engineer can explain to you, and the water stays on your property, then that's fine.
Yeah, the key with all of these is to get the water to penetrate into the ground rather than running off.
Right.
Running off over the surface so as to impact somebody else.
Okay.
So was there a consent to
Yeah, no,
the roof
absolutely.
leaders
I've asked my
and the roof
client,
leaders?
and they've agreed to all this, and it can be worked out between Mr. Chang and Mr. Bucko.
Yeah, I mean,
So-
some of the contouring is shown on the drawings you submitted, but you can't quite tell from this drawing what's on the rest of the property, what's high, what's low, and hence where. You usually want to go from high to low, because that's the way water flows.
Right. And I could provide some more topography on the plan to show the drainage flow.
That has nothing to do with what I'm talking
Yeah.
about.
So, Dimitri, just so I clarify that condition, is the board okay if it's dry wells or rain gardens, subject to
Yes.
Bob's confirmation? That's how you want it?
Well,
to-
Bob will
Yeah.
confirm either one.
Right.
Right.
I mean, you're not demanding.
No, I'm not
Okay.
demanding anything, I'm giving them a choice.
Right.
The water has to stay on your property.
Right.
However you want to keep it there, you could have.
Good answer. Not- we don't demand it.
Just has
We
to-
offer suggestions.
Just has to mitigate the additional runoff.
Yes.
Okay.
And any drainage from the pool that would occur, like if
Well,
it
that's what I
rained,
mean.
they have to lower the level in order to
Yeah.
get into the skimmers, where's that water going?
And you had mentioned the fact that they should look into tying in their roof leader, or roof
Yes.
line.
I suggested
Roof
that to
leaders.
help also, since they're over coverage by 5%.
Yeah, I mean, that you have to look at the total property.
Yeah, you have to
and
also
if-
remember that during the winter, when you have a covering on your pool, your pool is not in,
Right, it's not
impenetrable.
detention.
Right,
So
so you get 2 inches, 3 inches of water on top of the pool, it's gotta go out.
Okay.
Yeah, I'm not sure what we're going to have tomorrow.
Yeah, I know. All right, number 3, provide a detail of the proposed retaining wall.
We're not proposing any retaining wall, we're just removing sections of it.
So,
Are you saying it
What's it says in the
That-
plan,
there's removed portion of existing wall? Is that the top end of the pool?
Right. On the north side of the pool.
So
then
that,
what is,
what's that retaining wall, what's that wall do? How high is it?
Thick little rocks.
Oh.
Yeah.
Yeah, because since we don't have a full topo here, we can't quite tell what's what.
The pool is at 138, and I see 139, and I see it going up to 140.
Well, it is higher on the other side of the wall.
Right.
So it is retaining some soil back there, so.
But 1 foot is nothing. Yeah, I mean, where we get concerns is, I mean, the township's ordinance require if it's anything over 3 feet has to be engineered.
Which is not.
Yeah.
so the retaining wall is going to be removed?
A portion of it. And then
it's
we're
not
gonna
gonna-
grade out the rest of it.
It curves inward a little bit.
Yeah.
So in order to make the
Thomas,
pool
what-
kind of flat back in the property.
What's all this for?
Clarify that?
Sure. Make any factual
Yeah.
findings.
What's,
You're looking at that.
I'm looking at,
Area of disturbance.
yeah, I'm looking at the picture here, and there's a series of bars around the pool area on the north, west, and south side, I guess, if this is, although I don't know what faces north.
Is that the retaining?
Is that the area of disturbance?
Yeah,
Yeah.
is that,
Oh, that's the silt fence. That's for construction.
oh, but is that gonna stay there, or,
No,
No,
no, it's
no,
temporary.
That's only there during construction.
okay,
And any soil that goes as part of construction gets stopped by this silt fence.
okay, and then
This is the
after,
orange.
And then when construction is completed and they're starting to restore the property, then once it's restored, then the silt fence comes up and is removed.
so by restoring the property, you mean grading it?
Grading it, seed, whatever they do, sod, seed, plantings,
Okay,
just to stabilize it.
okay, so there's no fence gonna stay there or anything like that?
No, that all gets removed after construction.
Well, there's gonna have to be some fence somewhere.
I think it's on the outside of the property.
Right, we'll talk
Yeah.
about it.
Yeah, there's,
No, the existing fence is around the property line, Demetrius.
Oh, yeah, I see it.
Yeah.
what do you anticipate doing in the way of landscaping? And I'm thinking as much as anything about with regard to buffering around the pool from your neighbors.
That's number 6.
There are trees back there now, but they will supplement it with plantings, maybe some arborvitaes or something like that.
We have a whole row of arborvitae's back on the side where the slope goes down, right, where to the house on the left, that, you know, where in theory the runoff will go. So there's a whole line of flat. We'll put more trees in.
It is wooded back there currently.
Yeah.
Okay,
Okay?
number 4?
Number 4, that's, okay, so provide manufacturer's equipment specifications on the proposed water feature wall and pool equipment. I don't know that we have that information.
Not
yet.
right now. Once we come in for the pool permit with the building
Yeah,
department,
that'll-
then we'll
that'll-
submit all that.
That's okay, condition to
Yes.
submit all
Right,
that.
that's a condition.
Is that also, where is the pool equipment, the pumps and heaters, where's that?
We show it right now on the side of the house, on the east side of the house there. The proposed pool equipment there.
I have that called out as a potential variance in my letter.
Yes.
Why, because of the setback?
Yeah, I think it's within 25 feet.
Yeah, it looks like it would be.
Oh, because you say the setback of the house is 27?
Yeah, well, we can get to that, but yeah.
Right.
It would be a small variance, but, you know, we usually do like to see those screened, you know, stuff like that, so, but we can get there.
Yeah,
Okay.
Is that
there
on
any
the
way we
list?
can-
It's in my letter.
Oh,
Is there any way we can move that?
Yeah, I mean, we could actually, you know, I've seen them where they're actually only 2 feet wide, but a little longer. So if it's only 2 feet wide, then we don't need the variance.
I'm just concerned that, you know, you're gonna be digging up the property just to get the piping to the pool.
Yeah, that's not good.
Yeah, what about in between the paver patio and the
Right.
back, like the round
I mean,
one?
we could move it to another location,
Yeah,
yeah.
absolutely.
I mean,
Okay.
it's, that's
I would
flexible,
I would
yeah.
recommend
And that they
moving
do
it
that.
so you can avoid a variance, and so also potentially it's, you know, not as visible from
Right.
So
neighboring properties.
we would agree to a condition that be relocated to a non-variance position subject to the approval of the planner and engineer.
Yep, sounds good.
Okay? All right, I think we already dealt with the landscaping. Testimony on how all disturbed areas will be restored.
Topsoil and grass.
Okay? Testimony should be provided that the
Whoa,
exist.
whoa, whoa,
Go ahead, I'm
whoa,
sorry.
whoa.
You didn't say anything, I thought you were good.
That's because I was writing.
Go ahead.
If areas to be disturbed, you're just gonna be either seed or sod.
Seeds, yeah.
You may want to consider some plantings, because I think if you heard the board already, they're looking for some sort of nice plantings as opposed to just
Mhm.
grass.
Okay.
To, you know, just to enhance the visuals around the pool. How does the board feel?
Yeah, no, it's appropriate.
well, at least on the right side of the property, because I'm looking at the.
On the east side you're talking about?
Yeah, east.
So why
So
just, you
let's
should
try and take
just,
a look at when you're doing for like the dry wells or the rain garden, you know, some additional plantings.
Right.
To enhance
Okay.
that.
so Dimitri, just put on the record, you're looking at a Google aerial, right?
Yeah,
So-
well, we're looking at a Google area, we're looking at the neighbor's property, how far away it is, and what the visibility is. So obviously, if you put something against, between the two driveways, some sort of greenery to give you some privacy from your neighbor's house,
Okay.
and them not seeing you and you're not seeing
Sure.
them.
But reading this, it is 50 feet from the neighbor's house, the start of the pool.
Right.
Oh.
51 feet.
51 feet. So that's a nice distance,
Mhm.
but to also give additional privacy.
Right.
Yeah, believe me, I'm sure my clients do not want people from the neighborhood to have to look into their pool and vice versa, so. Okay, moving on then.
So we'll
Yeah,
just,
I
for
would
the
also note
record,
there is also a fence there. There has to be
Yeah.
a fence there.
It looks like a chain link fence.
so we'll have a condition,
Is it?
enhanced landscaping subject to board professional.
No,
fine.
it's,
Yeah.
you have a vinyl fence.
East side only?
No, it's not vinyl, it's like a little,
Yeah, because the west side
Aluminum.
has the,
Aluminum fence.
the septic system, Marty.
Right, okay, east side only.
Thank you. Okay. I think we just touched on it, but testimony should be provided that the existing fence, gates, and locks meet the township standards for pool enclosures.
Which they are, with self-locking gates and auto-closing. They are pool compliant.
And that's a township issue. If they're not, that'll be a township issue.
Right.
Right, it'll be a
Yeah.
code issue. If they're not,
Yes.
we're not going to get our permit.
CO.
Yeah, CO for the pool. All right, applicant will be responsible to repair any damage to the township's right-of-way during construction to the satisfactory of the township engineer. I'll answer that one, yes. We really don't have a choice on that. That's going to be a condition of approval. A tree removal permit may be required. Of course, if there is one required, we will obtain it. We will get all permits necessary. All remaining engineering issues, plan requirements have been addressed and are acceptable. We say, yeah, I think that's more a comment than a question.
Yep.
But we say great. Number 11, if approved, the applicant shall provide an as-built plan of the pool construction. We'll do that, correct?
Yes, yes.
Okay.
Yeah, I mean, that's we do that as a standard. There have been too many instances where the pool wasn't built where it was supposed to be.
That's not good.
I strongly suggest to the applicant that the surveyor mark the lines. We've had people come back here after it was built and they had to get variances.
Right, right.
So
And
if
they
it's
were-
not marked, then they
So
claim
we'll-
they didn't know where the
We'll stake the
where
rear
setbacks
line
are.
before, prior
The
to construction.
setbacks.
Yeah.
Exactly.
The setbacks on the side lot.
Right.
Yeah.
I think the rear is the critical one right now, so, yeah.
And I believe 12 and 13 are, again, just comments. They're not really questions for us. so.
Well, she has her own comments.
Well, Kate has her own
Yeah,
comments.
just briefly, we touched on most of what I addressed in my letter, the first part of my letter. The only thing that I just wanted to bring up, and I know that we've agreed, the applicant has agreed, and the board has mentioned, mitigation of stormwater. I was just curious because on that infamous 2004 zoning permit, it does specifically mention that, some piece of that had to be removed, or some piece of portion of pavement had to be removed to keep the coverage under 25%, which, who knows if they did that or not. So I was a little surprised to see, what's on this lot right now where it's up to already, I think, what did I have it at, about 29 and a half prior to this. So it's just one of those things where, I think we like to keep track of, and little things can add up with impervious coverage that, you might not think you need a building permit, you do, but stuff like that. So this is just a case where, I just want to make sure less about how we got to this place, but more that, the applicant should be aware that pretty much any construction going forward would trigger another impervious coverage there.
We are aware,
Okay.
very much so.
It happens over time. It's especially, on houses. Yeah, especially when you have a substantial driveway on there. But just this is a case where, you're over, and, you know, unless you were to substantially reconfigure the driveway, you know, you're not really getting under. So just wanted to bring that to the applicant's attention.
Thank you very much. And we agree with you 100%, everything you just said.
And that the fact that some of this is pavers rather than paved concrete also
Right,
impacts
they're
that
pavers.
calculation.
That was calculated properly, yes, the applicant did calculate
Kate,
that.
what's the current coverage? Just so I missed it.
Based on what the calculation on this property, excuse me, on this plan, I had it at approximately 29.4.
And we're going to 30.8.
Yes.
Is what we're.
So what they're doing here is really not that significant, but, you know, it still triggers it, and because of, you know, whether, you know, what had happened over the last 20 years or et cetera, they are over.
So the biggest thing that causes the number to be that high is the driveway.
Yes.
And this is a raised home, not home, but it's on a hill. So you don't want that driveway not to be what it is right now. I think it'd actually be a dangerous situation if anyone tried to change that driveway. You need it for the circulation.
And no one's asking.
No, nobody's asking that. We're just trying to clean everything up.
Understood.
You know, so if someday the applicant decides to sell a house, that everything is clean.
So yeah, you know, someone you change the driveway configuration, you
Right.
change the garage configuration, you no longer need that. Then suddenly, you know, we also want the residents to be aware that then they would have another 5% or something like that. So, but yeah, but now the maximum would be 30.8 with the conditional mitigation measures.
If it makes the board more comfortable, since we're already recording a deed restriction, I have no problem recording the resolution with the deed restriction. And that way, anyone who goes and buys this property in the future, it's all going to be there.
Good idea. Do you have anything else, Kate?
No, my only other comments were regarding the pool equipment and landscaping. And I think, you know, with regards to the bulk C variance criteria, they've agreed to mitigation measures that will, you know, reduce any potential impact on neighboring properties, et cetera. And I have nothing else.
Do any of the board members have any other questions about this application? Cora? Nothing? Jean? Jill? Dimitri? Usually have extra questions.
I'm just looking at the Google map, trying to compare to the survey to see if it has everything on there. That's what I'm looking at.
It can be hard because you don't always know what date the maps are from, and they can look very different depending on the time of year, which we realized with the last application we had up here. But yeah.
I think it was a little less. Is there some sort of deck when you come out of the house that goes all along the back of your house?
The front?
No, the back.
It's like a patio.
That's on the plan.
It looks like, I think that's a shadow.
Is that a shadow?
Yeah.
Yeah.
Oh, like an over.
Oh, yeah, no, that's.
Oh, the shadow.
It's black over
Those are shadows.
there. Okay,
Yeah, what's on the plans is what exists at the house.
okay. The fire pit is going to be relocated somewhere else?
Yeah, that's just-
I
there's
just
nothing
put-
there.
That was like a little Home Depot kit, I
I
think.
don't have any other questions.
Nothing.
Francine?
No.
Jason?
Yep, I'm good.
You're fine?
No, thank you.
You got everything on the record you need?
Public. Just
Oh,
open to public.
yes. Does any member of the public have any questions about the testimony and the application we've heard tonight?
Comments?
Do you have any comments? No? Let the record reflect that the public had an opportunity to speak and nobody volunteered to come forward. In that case, is any discussion by the board?
None for me.
Would someone like to make a motion to approve or to disapprove of the application with the conditions we've discussed?
Motion to approve with the conditions discussed
And formally not requiring a use variance.
and formally not requiring a use variance.
Yeah, that's an important part of
Thank you.
this whole thing. Is there a second to the motion?
I'll second it.
Roll call, please.
Dr. Blumenthal?
Yes.
Mr. Berkel?
Yes.
Ms. Campus?
Yes.
Dr. Latif?
Yes.
Mr. Luciani?
Yes.
Mr. Orfanatopoulos,
Yes.
and Ms. Perez.
Yes.
Congratulations.
Thank
Enjoy
you,
your
Mr.
pool.
Chairman.
You
Thank
probably
you.
won't have it this year yet.
Now we have to figure out how to pay for it.
Happy holidays, everyone.
And
Don't say rent out the apartment.
and as mentioned, the next step, our attorney will draft a resolution. He'll share it with you. And potentially in January, we can get an approval of the resolution, and that has to go through all the process to get approved, and then you can move forward.
Absolutely. Thank you so much. I really do appreciate it.
Thank you.
Enjoy.
Thank you.
Okay, item 4, draft minutes. We received the draft minutes from Loretta for the August 17th minutes. Does anyone have any questions or amendments to the minutes of that meeting? If not, is there a motion to
Not going to
approve
be
them?
heard tonight.
Who was involved? Dr. Shaw was not here that night, so anyone can make the motion, other than,
I make the motion to accept the minutes.
I will second the motion.
okay? All in favor?
Aye.
Aye.
Opposed? Minutes for August 17th have been approved. Moving on, item 5.
You want me to read it?
Yeah.
Okay. Item 5, 35 Telegraph Hill Road, Apostolos, Paul, Safarou, Block 50.425, Lot 62 in the R40A zone, zoning board variance number 466. Applicant granted variance relief for lot coverage of 29.49%, where 25% is permitted, a 22-foot pool patio setback, where 25 feet is required, and a 20-foot pool equipment setback where a 25-foot setback is required. Granted relief for a 13-foot 4-inch patio and seat wall setback where a 25-foot setback is required.
We received the draft of the resolution from our attorney. I know there were some discussions with the applicant about it, and it's been all reviewed.
Not with me, he's not represented, but I think they've communicated with Loretta, and they've resolved, I assume, their issue. Unless Courtney has any update, but I know he had an
Yeah,
issue
there was,
with
one item that
with
was,
the rain garden.
is a condition that was in here, and Loretta confirmed on the tape that that was exactly what was testified
Right.
during the meeting. So, are there any additions or corrections to the resolution?
So this applicant is putting both a rain garden in and a dry well for his pool, 2 things.
That's great.
Yes.
So, if there are none, is there a motion to approve the resolution as submitted?
Motion to approve the resolution as submitted.
I don't think
You weren't.
you were absent.
Were you here that day?
17?
It was 11:09.
Oh, my birthday, you're right. Was it?
I was at Disney.
Good catch. Good catch. We're testing.
I will motion to approve.
Is there a second?
I'll second it. Was I here?
Gene?
No, you were not.
Gee, I'm not sure myself.
That's why, so we went to test it.
Can I second the motion? There you go.
Highly bored up here, Courtney, you better watch out for them.
Now I know where I was on my
Roll
day.
call, please.
Dr. Blumenthal,
Yes.
Ms. Campus,
Yes.
Dr. Latif,
Yes.
Mr. Orfanatopoulos,
Yes.
and Ms. Perez.
Yes.
Item 6 is the resolution on the Dementia Center, which is a much more complex resolution. We've indicated earlier, we're going to ask that we defer that without further notice to our reorg meeting on January 11th. So we're not going to hear that tonight. It's going to take a few more minutes to read that resolution. It's 35 pages, written by a lawyer. Although I want to thank Marty, because it was a lengthy set of hearings, and I believe he's captured 99%, and I'm worried about the last 1%.
Good job, Marty. We want it perfect.
Okay, with that, is there any other business for this evening?
Mr. Chairman.
Yes.
I'd like you to know who the
Twice.
gentleman is sitting here.
One
This
yesterday,
is
one
Mike
today.
Brushka. He's an engineer that works with me, and he wanted to come to tonight's meeting to see how
has got just
the board's
attachment.
operating.
Oh, welcome.
Welcome.
I hope it was informative.
And then,
It's the most
Kate, do you have anything else for tonight?
I do not.
This is
Thank you all for another great year.
351 today.
Well, that's, I just want to thank all the board members, Courtney for her introduction today, Kate, Bob, our new Colin, minute taker, and all the board members for their efforts during the year. We've had a couple of difficult
You did a
cases.
good job. You did a very good job tonight. A couple weeks ago, we had a few interruptions.
But, you know, it was a difficult year with a couple of very complex cases. We listened to each other, we worked together, and it made it fine. So we have a present from Loretta, and we can just pass it around.
I make a motion, we close the meeting for the last time.
I second that motion.
You get it, you get it open, you can pass it around.
Not more sweets.
Okay, thank you, and there was a motion to adjourn. All in favor?
Aye.
Aye. Opposed? We're closed for the year. Thank you all.
No, I can't, no, I can't.
Pass it down.
Oh,